There you heard the chilling account from the surviving victim in the James Colley case, where he came into the house shooting, and she did survive that attack. Let me ask you, Laura, did you find that her testimony was credible and that she's likely traumatized by the events that she witnessed and went through?
Oh, certainly. I mean, there's nothing about her demeanor that would indicate a lack of credibility. She certainly seems upset and traumatized. But I will say this, we were talking about child witnesses, and her demeanor on the stand, while troubling, while clearly traumatized, still is not going to be nearly as emotional as a young child doing the same thing.
All right, that's a perfect segue for me to introduce our other special guest today. And here on Law and Crime, Judge Birmingham from my home state of Texas. Always happy to have you. Thanks for joining us.
Well, I'm glad to be here. It's good to see you.
Thank you. Good to see you. So let me ask you, in your experience, what is it like for you as a judge to be involved in a case where a surviving victim or a child is going to testify, like in the Monell case where the 12-year-old may or may not testify, but I think it's likely?
Yeah, you've got to be sure to provide an atmosphere that is comfortable in order to get out the truth without being too parental almost. You know, you want to give the child an opportunity to be heard, and you want to make sure the lawyers are using small words. When I give the oath to the really small kids, I got to make sure they understand the truth, what it means to tell the truth versus telling a lie. So you've got to watch your language. You also have to watch being too intimidating, but you also have to watch them. You want to keep them steering along the right path, you know, and kids tend to talk about things that just pop into their head, so you want to also try to keep them on the straight path.
So let me ask you this. Here's the real question we want to know the answer to. How often do you see lawyers effectively question a youth or a child on the stand?
Well, some of the lawyers are really, really good at it, and obviously experience helps, whether that's experience from having children of your own or just trying these types of cases. It never does anybody any good to just try to beat up on a child the same way you would try to beat up on cross-examination, let's say, of an expert witness or an accomplice or something like that. You've got to treat them with kid gloves, and you've got to be able to use the small words that they can understand. So it is definitely an art form, and some lawyers are way better at it than others.
All right, thank you. We're happy you're going to still be with us. We're going to take a short break and come back and join us as we resume trials here on Law and Crime. Welcome back. We are going to continue to analyze the differences and, more importantly, the similarities, because they are numerous, between James Colley, a Florida defendant who was convicted, versus the 2019 live trial that's going to be getting underway after lunch today. We expected them to resume at 1:30 Eastern Standard Time, and as soon as that happens, we'll go back to that trial. In the meantime, though, it's really interesting to note that in both of these cases, the estranged wives had numerous injuries. So let's listen first to the testimony of the medical examiner from the James Colley case about the injuries that his estranged wife sustained.
It would not be received prior defensive injuries on the hands and legs, which means that if the person was rendered paralyzed, we would say, well, that wound was received after all the injuries to the hands and legs, because that person was still able to defend themselves by putting the extremities in front of the weapon. So we know that at that point, the injuries to the hands and legs were received first. So in that kind of logic, we can actually extrapolate and scientifically guess which is the order of the wounds, but not for every single wound.
Okay. Doctor, would clothing have the effect of preventing that stippling, as you were indicating, there would be evidence of a close-range gunshot? Would that have the effect of preventing some of that material from tattooing the skin, as you described?
Clothing would prevent or filter out the stippling or that cloud of hot gas coming out and hitting the skin, causing the stippling would be filtered out, and the contact range could never be filtered out. That would be always seen, even if somebody's shot through the clothing. However, the close range would be diminished in appearance. It could appear as distant.
Right. And with regard to all these injuries, just so I don't have to ask you the question with each one, was there any evidence on any of the injuries of a contact or close distance range?
No, I have not seen any evidence of that. When the bullet, were you able to determine sort of the track of the wound here as it entered the skin?
So the medical examiner has described the number of different shots and injuries to the estranged wife, Amanda Colley, in the James Colley case. Let me, Laura, ask you first, what does that mean to you in terms of domestic violence, rage? Any of those things come to mind when you hear about those injuries?
Oh, of course. I mean, when you're talking about injuries that start out a little farther away, get closer and closer, I mean, this is a crime of rage. There's just no question about it. And that goes along with everything we know about this case, which was, you know, they were an estranged couple. There had been courtroom proceedings between them, and things were likely escalating. And seeing her standing in front of him did nothing to dilute his rage, but likely did everything to increase it, which is why we see just so much violence in this killing.
A horrible crime of passion. So, Judge Birmingham, let me ask you to compare that to the Manel case that we're going to be watching live in terms of, it's my understanding that he allegedly stabbed his estranged wife 48 times. What do you make of that?
It's going along the lines exactly of what she was saying. These domestic violence intimate partner killings are usually frenzied killings. Some people refer to it as overkill. They're numerous in their wounds. They're numerous in their intimacy. And the medical examiner is a very, very powerful witness to show not only the position of the parties, how far away they were, how close they were, whether there was defensive wounds and those sorts of things, but they can also reveal the position of the mind of the killer. That is an angry, rage-filled killing, to do that 48 times, or to shoot somebody numerous times, or to have a contact wound. I mean, there's no mistake about it. It's not self-defense. It's nothing like that. That is where you have one purpose and one purpose in mind, and that is to exert your rage and your anger against somebody else. It's the ultimate tool of power and control that domestic violence abusers have over their victims.
And so in the Manel case, would you expect that the prosecution is going to have a medical examiner testify about the defensive wounds or the stab wounds or whatever else they may show us?
Absolutely. That's going to be one of their key witnesses. You know, when I was trying cases, and when I see the lawyers these days trying cases, the medical examiner is the circumstantial proof of their case. I mean, if you think about it, the medical examiner is not a direct witness. They don't see what happened, but they have the objective proof about what happened. There's no debating that there is gunshots residue on the skin or not. You know, there's no doubt that it was a bullet or not. You know, those types of things. And it's from those conclusions that you can draw this picture. You get a really clear picture. You can imagine a woman who, with her hands up, is going to have gunshot residue coming in maybe on her hands and her fingers, or, you know, you can get a really clear picture about how this crime happened. And not to mention the fact that most jurors don't usually walk around seeing people that have been murdered or shot. So it's a very shocking, emotional reaction that the jurors are going to have. Plus, they're going to be given expert testimony that will very conclusively show the relative position of the parties, both physically and, as we've talked about, mentally.
All right. So I also, after this break, at some point, want to talk about the fact that both of these crimes are committed in the homes of the estranged wives. But first, we're going to take a short break. Come right back. So this judge is doing what all judges have to do in a jury trial, which is give the jury instructions to the jury before they begin hearing evidence. Judge Birmingham, let me ask you first. In some states, or do you know, or at least in Texas, can the jury take notes about all these details he's telling them about how to determine if someone's credible or not, and expert witnesses and discrepancies?
It's a lot. And jurors can take notes in Texas. They cannot take those notes back with them during deliberations once those deliberations start. That's the rule here in Texas. I know other states go as far as allowing jurors to take notes into the deliberation room, to allowing jurors to ask substantive questions, which is astonishing to me. But they will at least have the jury charge. Every jurisdiction that I'm aware of will at least allow the jurors to take with them the jury charge during their deliberations, so they will at least have that. And that has all the law necessary to enable them to reach a verdict.
All right, Allura, anything else you know about New Jersey specifics?
Yes, as a matter of fact, I'm a New Jersey lawyer. This trial is happening not too far from where I live in Cumberland County. New Jersey is one of the few states that has express permission for jurors to take notes. But what are done with those notes and at what point those notes can be taken and how those notes can be taken is up to the discretion of the trial judge.
And let me ask you both, I think we can all agree it is a lot of information to throw at a jury because it's all about the legalities and how you define an expert and what your job is when it comes to the expert. So let me ask you first, Allura, do you think it's a difficult amount of information for anyone to take in as it's being taught to them?
I do. I think it is a tremendous amount of information. What we ask of jurors to pay attention to complex information coming at them for hours and hours in an arena that many of them have absolutely no experience is really asking quite a bit, which is why jury service is so important and why when we do it, we need to give it so much attention.
All right. So, Judge Birmingham, I know as a judge that I have not found any shortcuts, so to speak, that it's part of the job, part of what you have to do. What about your experience? Is there any way to make it even more exciting or easy for the judge, for the jury to take in or not?
Yeah, exciting might be a stretch. If I could write an exciting jury charge, I think I'd be the toast of the town. But I think that the rules are very complicated, but it's really up to the art of the advocate to break down the very simple rules. And I think what you'll find in most trials is the lawyers will tell you where the big fight is. You know, we can pretty much agree on everything except for what this expert says or what this expert means or something like that. So there really is a lot left to the advocate. And I would say it really is up to the judge, though, to have a clear and concise jury charge, as clear and concise as the law will make it. And a lot of that is reassuring them from voir dire all the way through the process about what these certain words mean.
So far this judge has been pretty easy to understand and how he's spoon-feeding it, so to speak, in a very effective way. But let's watch some more of his jury instructions and see what he's presenting to them now. All right, so that's the defense attorney making their opening statement. And I think that if any of us listen to what the prosecution expects to show, we then say, what kind of defense could possibly be mounted because you have a 12-year-old who has allegedly seen this crime committed and saw the father stab the mother? So here the defense just stood up, and I'd like to talk to you first, Allura. Let me ask you your opinion of the defense's analogy in trying to say, listen, the prosecution's going to give you a lot of responses, but no real answers to who killed her.
I don't think this is going well for the defense. And to be fair, the defense doesn't have a lot to work with here. So let's start from there. This is already a difficult defense opening. However, it's still going disastrously, as far as I can tell. This analogy of that children, you know, if you ask them what they had for breakfast, they might say something, but it might not be correct. I think I understand where she's trying to go, which is to say that children are not the best witnesses, don't always have the best recall, and are highly suggestible. I get that. But to make an analogy that to something obviously totally trivial and to somehow try to equate that to how a child would give a story of seeing one parent murder the other, it doesn't make any sense, and it actually borders on being kind of offensive. And I think what she could have said, if there were any facts to back this up, were this child may have been suggestible, maybe he was giving these answers to please the police he were talking to. That might have made a little bit more sense, but to act as if a child would be incapable in some way of giving a credible story of something so unbelievably traumatic, to me just doesn't really work. I don't think this is working at all.
So, Judge Birmingham, let me ask you, if you'd now listen to the prosecution opening statement and defense opening statement, where do you sit as a judge if you heard both of those statements? And I know you could not make any conclusions at that point, but if you could, how do you feel about which direction the trial's going at this moment?
Are one of my favorite parts of the trial. It's interesting to hear the prosecution lay their case out. One of the things that strikes me, and I'm hopeful that we'll hear the defense go down this pathway maybe during the trial, is that I might expect that if there is a knife that's recovered in my house, my fingerprint's going to be on it. I live there. I might expect that my DNA is going to be in some of the clothes around the house too. I mean, so, you're going to want to see the defense try to poke holes in some of this evidence that connects him to the killing. He's going to have some trouble explaining his son's story, number one. Number two, he's going to have a lot of trouble explaining why those knives were hidden. Number three, he's going to have a lot of trouble explaining why he was gone for 2 weeks, leaving his kids, I guess, alone and hiding out in the forest somewhere. So there's some problems they're going to have to deal with here.
Yeah,
we'll have to see.
I think that's what's going to be interesting about this trial, and how does the defense make those points and make arguments to convince a jury of reasonable doubt. That's why we like covering these trials on Law and Crime. Judge Birmingham, thank you so much for joining us today. We always love having you as one of our legal analysts on Law and Crime.
Well, it's an honor to be here, and I got to tell you, I can't wait to hear you, Law and Crime, get a shout out whenever we talk about how this case isn't like CSI or something like that. I want somebody to say, but this case is exactly like Law and Crime because it's all real.
Awesome. Thank you so much. All right, we're going to take a short break, but come back after, and we're going to continue to cover the trial live.